Welcome. Thank you for taking the time to receive this important government ethics training provided by the city's Public Ethics Commission, or PEC. The PEC is an independent city board that oversees compliance with Oakland's campaign finance, transparency, lobbying, and ethics laws in order to ensure fairness, openness, honesty, and integrity in city government. The PEC facilitates policy and technology improvements, enforces violations of the law, and educates city officials, staff, and citizens about ethics-related laws and policies. The PEC developed this government ethics training to provide you with an overview of the many local ethics laws that apply to you in the course of your work for the city. It should take you approximately 1 hour to complete this training. If you are an elected official required to receive AB 1234 state-required ethics training, you must still complete the 2-hour state-approved training every 2 years to comply with the state law. Here are some of the major topics that will be covered in this training. Form 700 Statement of Economic Interests Reporting. Restrictions on gifts from others. Conflicts of interest. Restrictions on outside, incompatible activities, employment restrictions upon leaving the city, misuse of city resources and position, bribery, nepotism, separation of city government branches of power. After this training, we hope that you will be aware of government ethics laws, be able to spot ethical issues, yellow flags, when they arise, know where to go for help, lead by example to promote ethical service. Note, this training is intended to provide you with a general overview of the main ethics laws that apply to you as a public servant in Oakland. This is not considered legal advice. If you have a specific ethics question or need legal advice, please contact the Public Ethics Commission. Government Ethics Act, GEA. The Oakland Government Ethics Act was passed by the City Council in December 2014. GEA is intended to provide a clear, comprehensive, and locally enforceable framework of laws that ensure that Oakland City government operates with integrity. Government decisions are made on the merits and in the best interest of its citizens and not for private or individual gain. Rules are clear for public servants, and the law is fairly and effectively enforced. Who does GEA apply to? The Government Ethics Act applies to all public servants. Public servant includes elected or appointed city office holders, city board or commission members, including port commissioners, city employees, full or part-time, consultants who must file a Form 700. If you are taking this training, you are a public servant. And note, OUSD school board directors are not considered public servants under GEA, but some provisions of GEA expressly apply to them. Upon assuming your position, and each year thereafter, you will need to complete and submit a Form 700, a Statement of Economic Interests. This can be done electronically or in hard copy to the City Clerk's office. You can find instructions on how to set up and file your Form 700 electronically on the city's online filing portal, NetFile. Form 700. What is it? A Form 700 is a document that includes certain details about your personal finances that could become a source of conflict for you in your city service. Allows members of the public to monitor the financial interests of a public servant. Helps public servants to be aware of their own potential conflicts. When must it be filed? Within 30 days of assuming or leaving office. April 1st every year, covering the preceding calendar year. What must you disclose on your Form 700? It depends on your disclosure category and items relevant to your work decisions. What to disclose on the form. To complete the Form 700, review your disclosure category in the city's Conflict of Interest Code. The code provides a list of positions required to file a Form 700 and includes disclosure category numbers relevant for each position. Positions are listed by department and will reference disclosure category numbers between 1 and 18. Once you know your disclosure category number, check the code's index to see what is required to be disclosed for your category. For example, all citywide agency, department, division directors are listed as Disclosure Category 1. This means that they must disclose all investments and business positions in business entities, sources of income, and interests in real property. Check out the city's Conflict of Interest Code to see what your disclosure category is. If the Conflict of Interest Code assigns you to Disclosure Category 1, 2, or 3, you will generally have to disclose all investments and business positions in which you are a director, officer, partner, trustee, employee, or hold any position in management, as well as sources of income, interest in real property, and gifts from reportable sources. Generally, only those interests that are located in or have done or will do business in Oakland are reportable. If the Conflict of Interest Code assigns you to a disclosure category other than 1, 2, or 3, you will have to disclose a narrower range of information, which varies based on your position and your department. Persons in these categories shall disclose investments and business positions in business entities and income more specifically limited to certain sources, types of services, or supplies, or other industry-specific restrictions. And note, unless your disclosure category specifically says otherwise, you are required to disclose not just your own economic interests, but the economic interests of your spouse and immediate family. Immediate family includes your spouse, domestic partner, and dependent children. However, there are some economic interests, such as gifts and non-community property income, where you don't have to report the interests of your spouse or domestic partner. For example, a Program Analyst 3 position in the City Administrator's Office is in Disclosure Category 13, requiring the individual in that position to disclose investments and business positions in and income from business entities providing supplies, service equipment, or machinery of the type used by the city. On the other hand, a Program Analyst 3 position in the Department of Housing and Community Development is in Disclosure Category 1, requiring the individual in that position to disclose all investments and business positions in business entities, sources of income, and interests in real property. Make sure you check the city's Conflict of Interest Code to find out if your position is required to file a Form 700 and what financial interests you are required to disclose. If you have a question about what to report on your Form 700, contact the California Fair Political Practices Commission, or FPPC, and note, the California FPPC is responsible for the administration and enforcement of the Political Reform Act and also created the Form 700. The Oakland PEC can also enforce the Form 700 requirements. In addition, the hard copy of the Form 700, which can be found on the FPPC's website, includes helpful instructions on what and how to report specific financial interests. Gifts. Among the required items to report on the Form 700 are gifts given to you. Again, reporting of gifts depends on your disclosure category in the city's Conflict of Interest Code. The next section will explain gift rules and exceptions and will help you to identify potential yellow flags as issues arise in your work for the city. A yellow flag means possible ethics law violations. What is a gift? Any payment or other benefit that confers a personal benefit for which you did not provide payment or services of equal or greater value. Gifts don't always have bows. They can include a discount or rebate that is not made to other members of the public, including meals, food, and drink, including tickets to events, certain kinds of travel, including professional or personal services. Gift restrictions. Potential influence rule. No public servant or candidate for city office can accept a gift when it is reasonably foreseeable that the public servant or candidate could be influenced by the gift in the performance of an official act. This includes gifts of any value, and this prohibition applies to all public servants, regardless of whether you file a Form 700. And note, avoid rationalization traps such as, "I deserve this because..." If you're receiving a personal benefit for merely doing your job, that is a yellow flag, and you should probably call the PEC to check it out. In addition to the potential influence rule, all public servants are limited from receiving gifts as follows. $50 limit on persons doing business with the city. No public servant may solicit or accept more than $50 in gifts or loans each year from a person who the public servant knows or has reason to know is one of the following: a person doing business with or seeking to do business with the department of the public servant, or a person who during the prior 12 months knowingly attempted to influence the public servant in any legislative or administrative action. $250 general gift limit. A public servant or candidate for city office who must file a Form 700 may not accept gifts of more than $250 from a single source in a calendar year. Multiple gifts over the course of the year are aggregated. $50 reporting threshold. A public servant, Form 700 filer, must report on the Form 700 all gifts of over $50 in aggregate per year. How is the value of a gift determined? Fair market value, face value, cost price of similar items. And note, see Form 700 instructions for more information about reporting requirements. Restrictions on the source of gifts. A lobbyist or lobbying firm may not be an agent or intermediary in making a gift from another person to a public servant. Any intermediary of a gift is required to disclose the true source of the gift to the recipient. And keep in mind, a public servant or candidate for city office may request advice from the PEC regarding the legality of accepting a specific gift. Exceptions to the gift limits. The following gift exceptions are not required to be reported on Form 700. Gifts from your spouse or former spouse, child, parent, grandparent, grandchild, brother, sister, current or former parent-in-law, brother-in-law, sister-in-law, aunt, uncle, niece, nephew, or first cousin, or the spouse of any such person. Gifts commonly exchanged between you and another individual on holidays, birthdays, or similar occasions to the extent that the gifts exchanged are not substantially disproportionate in value. Personalized plaques and trophies with an individual value of less than $250. Items received by a public servant during an employee gift exchange, so long as the items received are provided by another employee of the agency and the gifts are not substantially disproportionate in value. There are more gift exceptions. Please see the FPPC fact sheet on gifts. Gift exceptions requiring alternate reporting. There are two types of gifts that are considered exceptions to individual gift reporting, so long as the payments meet certain conditions and that they're reported by the city on separate forms as follows. Gifts to the city for agency business, Form 801. Gifts or donations made to an agency and used by one or more public servants in the agency for agency business should be reported on FPPC Form 801. This may include travel payments, reimbursed payments, conference fees, or other uses by an official. If properly reported on the Form 801, then the gift need not be reported on the Form 700. You should carefully review the instructions to the FPPC Form 801. Tickets to events, Form 802. Gifts or donations made to an agency or public servant in the form of tickets to an entertainment, recreational, or sporting event must be reported on FPPC Form 802. The ticket or pass cannot be earmarked by the original source for use by a particular agency public servant, and the agency must determine in its sole discretion which public servant may use the ticket or pass. The Form 802 is also used to report tickets provided for public servants who perform a ceremonial role on behalf of the agency. For a ticket to be exempt from reporting on the public servant's Form 700, the city must have a written policy stating the public purpose for distribution of the tickets. Tickets received and used pursuant to the agency's written policy must be reported in a timely fashion on the Form 802 or in the city's electronic filing system for Form 802 data. Here in Oakland, the city's ticket policy requires that the distribution and use of the ticket be for a public purpose. See City Council Resolution 82032. Behested Payments, Form 803. An elected official who raises money or otherwise solicits payments from one person to be given to another individual or organization, such as a nonprofit organization, may be required to report the payment on FPPC Form 803. Generally, a payment is considered behested and subject to reporting if it is made at the request, suggestion, or solicitation of, or made in cooperation, consultation, coordination, or concert with the public servant. It is made for a legislative, governmental, or charitable purpose, and it does not qualify as a gift made for personal purposes or a contribution made for election-related activity to the elected official. There are no limits on behested payments. However, state law requires the reporting of behested payments that total $5,000 or more per calendar year from a single source. Public servants must submit Form 803 reports within 30 days of the date on which the behested payment meets or exceeds $5,000. Now let's apply these rules to a few hypothetical situations. First, meet Rick. Rick is a contract compliance officer for the city. Rick falls in disclosure categories 4 through 15, which requires him to disclose income received from investments or in businesses that provide services and supplies to the city. Rick is filling out his Form 700 and is trying to determine whether he needs to disclose a gift worth $500 he received from his neighbor Paul, who is a consultant that does not do business with the city. Does Rick have to report this gift? That's right. You selected the correct response. Rick deals with a lot of private companies in his job as a city contract compliance officer. He is invited out to dinner by Veronica, a salesperson who represents one of the companies that Rick deals with regularly. Rick's portion was $90. Veronica picks up the tab for both herself and Rick. Is this okay? That is correct. A public servant may not accept a gift valued at more than $50 from a source that is doing or seeking to do business with the city. Also remember that a public servant may not accept a gift if it is reasonably foreseeable that the public servant could be influenced by the gift in the performance of an official act. Is it possible to ungift a gift? Yes, if you do one of these things within 30 days of receiving the gift: pay for it, donate it to a 501c3 without taking a deduction, return the gift. If you are ungifting a gift by paying for it, you only need to pay for the portion of the gift above the gift limit. And here's a tip. The FPPC's Gift Tracker app is a great tool that helps keep track of the gifts received in a calendar year and provides a quick and easy way to populate Schedule D, the gift reporting schedule of the Form 700. You can download the app here. Contact the FPPC or the PEC for advice on accepting or reporting of gifts. Conflicts of interest. Under the Government Ethics Act, a public servant cannot make, participate in making, or seek to influence government decisions in which they have a financial interest. The 5 categories of financial interests include real property, sources of income, business investments, employment, or management, gifts, personal finances. See FPPC Fact Sheet Recognizing Conflicts of Interest. Real property. Your real property counts as a financial interest if it is within 2 miles of Oakland city limits and your interest in the property is $2,000 or more. Property in which you rent on a month-to-month basis does not count as a financial interest. Further, existence of a financial interest may trigger a conflict of interest in a government decision if the financial interest is reasonably foreseeable and material. These standards are defined in state law and require a detailed legal analysis based on the facts of your situation. If there is any possibility that you might have a financial interest in making, participating in making, or influencing a decision, contact the PEC or FPPC for advice in advance of your participation in that decision. Sources of income. You have financial interest in any source of income of $500 or more. It includes your wages and salary, interest payments, dividends, profits from businesses you own in whole or in part. It includes money received from rental properties you own. It also includes money from consulting work or secondary employment. Business investments, employment, or management. Investments include stock and business ownership. You can have a financial interest in a business entity in the following ways. 1. If the entity does business in Oakland and you have an investment of $2,000 or more. 2. If the entity does business in Oakland and you are a director, partner, manager, officer, trustee, or employee of that entity. Gifts. A source of gifts promised or received of more than the gift limit received in the last 12 months. Personal finances. The income, assets, and expenses of your immediate family count as your financial interests. Immediate family includes your spouse and dependent children. Gifts received and investments made by your spouse are also considered personal finances. What is considered a governmental decision? A governmental decision includes, among other things, taking any action, appointing someone to a city office or position, committing your department to a course of action, entering into a contract, or voting on a matter. What does it mean to make, participate in making, or seek to influence a governmental decision? Participate in making can mean negotiating, providing advice, or preparing recommendations for the decision maker. Seek to influence means using your position to try to affect the outcome of the decision, such as by communicating with your supervisor or members of your board, commission, or council. What happens if you have a conflict? You must abstain from any involvement in a decision-making process affecting a financial interest. You must avoid not only any role in the final decision, but also in all of the discussions and planning leading up to the final decision. To avoid being involved in a decision, you should take the following steps. Do not discuss the matter with or influence staff or colleagues. Publicly state the nature of the conflict at the meeting if applicable. And if you're an elected official, leave the room. Additional conflicts rules specific to contracting. A public servant may not make or participate in making a contract in which he or she has a financial interest. Financial interest exists if there is any potential for the public servant to recognize a financial gain, or if the interest causes the public servant to have divided loyalties. Section 1090 violations can lead to serious civil and criminal consequences, including up to a $5,000 fine and/or imprisonment and a lifetime bar from holding office in California. Section 1090 is complex. Contact the PEC for advice. Examples of violations. The city's procurement officer recommends that a contract be awarded to a company that employs the procurement officer part-time. A member of a city board or commission is the CEO of a company seeking a contract for services from that board, and the board member votes on the award of that contract. And note, if there is a contract conflict of interest issue, the entire governing body is precluded from entering into the contract. This is Tyra. Tyra is a member of the Planning Commission. In her private capacity, she also works as a consultant to restaurants. Less than 1 year ago, Pete's Pizza, a popular restaurant chain, paid Tyra $500 to help figure out a sustainable location for their new restaurant. Pete's Pizza was pleased with the location, but to open at that location, the company required the Planning Commission's approval of a permit. Last week, Tyra learned that the Planning Commission would be voting on Pete's Pizza's permit. Can Tyra vote? That is correct. Because Pete's Pizza is a source of income for her, Tyra cannot make any governmental decisions about that company. Let's assume that Tyra wasn't the one who did the consulting work for Pete's Pizza, but her husband Joseph did. Joseph was paid $1,000 to help Pete's Pizza find the perfect Oakland location. Can Tyra vote on the permit? That's correct. Income includes any community property interest in the income of a public servant's spouse. Therefore, Tyra's community property share of Joseph's $1,000 income from Pete's Pizza is $500. Let's change the hypothetical again. Assume that neither Tyra nor any immediate family did consulting work for Pete's Pizza, but that she owned stock in Pete's Pizza. Could she vote on the permit application? That is correct. She could vote, but since Pete's Pizza operates in Oakland, her investment must be less than $2,000 in order to avoid Pete's Pizza becoming a financial interest. Incompatible public offices. A public servant shall not simultaneously hold 2 public offices that are incompatible. Incompatible means either of the offices may audit, overrule, remove members of, dismiss employees of, or supervise the other office or body. Based on the powers, jurisdiction of the offices, there is a possibility of a significant clash of duties or loyalties between the offices. Public policy considerations make it improper for one person to hold both offices. When 2 offices are incompatible, a public servant is deemed to have forfeited the first office upon taking the second office. This rule does not apply to an employment position or a governmental body that has only advisory powers. Conflict in office by mayor and council members. The mayor and members of the council shall not hold any other municipal office or any other office or employment to receive compensation from the city, or be appointed or elected to any office created by the council while he or she is a member thereof, until at least 1 year has passed after the expiration of the term for which he or she was elected. Prohibitions related to political activity and solicitation of contributions. A public servant or candidate for city office may not directly or indirectly solicit a political contribution from another public servant unless the solicitation was made to a significant segment of the public, which may include public servants. Activities while in uniform. A public servant may not participate in political activities while in his or her city work-related uniform. Political influence. A public servant may not use his or her power to influence the securing or denial of any person's appointment or position in exchange for corrupt condition or consideration. Other than specific legal rules such as the above, no restriction shall be placed on the political activities of any public servant. It's election season, and Rick, the department director, starts volunteering for a candidate for state senate. He knows that his two assistants, Hank and Hannah, support his candidate. Is it okay for Rick to ask them to contribute to the candidate? That is correct. Rick cannot ask a subordinate to make a contribution to a campaign. Post-employment restrictions. Prohibition on switching sides. After leaving the city, you may not represent any other person or entity in a transaction where the city is a party if you have worked personally and substantially on a particular matter. A particular matter may include a contract, grant, permit, or similar transaction. For example, a city employee, as staff to a council member, advised the council member regarding a particular city contract that went through city council for approval. The city employee, upon leaving the city, may not represent or communicate on behalf of the contracted company in relation to the city on that contract, or even advise, assist, or consult the company as it relates to the contract. The prohibition is permanent, but limited to the particular matter, which in this case is the specific contract. 1-year lobbying ban. For 1 year after termination of your employment or service with the city, you may not communicate with your former department or board with the intent to influence a government decision on behalf of another person or entity. For the mayor, city council members, and their senior staff, the 1-year lobbying ban extends to all city departments. For example, after her term expired, a former commissioner of the Children's Fund, Planning and Oversight Commission, took a position as director of a local nonprofit that provides youth services in Oakland. The former commissioner cannot lobby her former board for a period of 1 year. Going to work for a contractor. You may not accept employment or pay from a person or entity that entered into a contract with the city within the preceding year or you personally and substantially participated in the award of that contract. For example, a city employee participated in the awarding of an IT contract with a vendor. He leaves his city job and is offered a job working for the vendor. The former city employee cannot be employed by or otherwise receive compensation from the vendor for 1 year after the city employee's participation in the contract. And note, it doesn't matter that you weren't thinking about your next job at the time you were working for the city or that the job was offered to you after you left the city. If the legal test is met, it is a violation of the law. Influencing prospective employment. A public servant may not make, participate in making, or otherwise seek to influence a governmental decision affecting a person or entity with whom the public servant is discussing, negotiating, or has entered into an agreement concerning future employment. In other words, you can't impact a decision about a company with whom you have submitted an employment application. For example, a building inspector cannot approve a commercial development permit for a company at the same time he is applying or discussing employment with that company. While a public servant cannot influence action regarding a future employer, the public servant also may not influence approval or a decision on a contract that involves the public servant's former employer, if within 1 year of the public servant having worked for that employer. Conflicts of interest are important to protect the actual and perceived integrity of city government to ensure that the public's interest is protected. Contact the PEC for advice if you ever have a conflict of interest question. Rick, a department director, and Veronica, a vendor, are negotiating a new contract between her company and the city. They chat about the details over dinner. Veronica mentions that her company has been impressed with Rick and wants to interview him for a job. Rick goes on the interview. Is this okay? That is correct. In order to avoid violating the law, Rick is prohibited from pursuing a job offer with any company with which he is actively working with on his city job. Misuse of city resources. The California Constitution requires public funds to be used for a public purpose. A public servant may not use or permit others to use public resources for campaign, personal, or non-city purposes. What are public resources? Any property or asset owned by the city, including but not limited to computers, land, buildings, facilities, funds, supplies, telephones, equipment, vehicles, travel, and city-compensated time. What is considered use of public resources? Any use of public resources that results in a gain or advantage to the user or a loss to the city for which a monetary value may be estimated. Can a public works employee use his take-home city pickup truck to work at his private landscaping business on the weekends? That's right. You selected the correct response. Misuse of city position. A public servant or candidate for city office may not use his or her position or prospective position or power to induce or coerce any person for private advantage, benefit, or gain. Examples of violations. A city inspector tells a person applying for a home remodel permit that the remodel will only pass inspection if the owner uses a company owned by the city inspector's friend to do the remodeling. A city employee tells a parking technician that he will use his connections at City Hall to get the parking technician fired if the parking technician issues him a parking citation. Confidential information. While serving as a city public servant and after leaving public service, you may not disclose confidential material or data that you acquired in the course of your official duties. In addition, you may not use such material for your own interests or personal gain. Bribery or quid pro quo. This for that. You may not solicit or accept anything of value, whether a gift, cash, or other benefit, in exchange for the performance of any official act. Beware of this for that. Think about what you would say if someone approached you. Prohibition on payment for office or appointment. A public servant may not give or promise to give to any person any money or thing of value in consideration of having been or of being nominated, appointed, voted for, or elected to any office or employment. Prohibition on nepotism. You may not make, participate in making, or otherwise seek to influence a decision of the city regarding an employment or contract action involving a relative. In addition, a public servant may not supervise another public servant who is also a relative. Exception: this prohibition does not apply to temporary assignments, such as working in overtime or traded shift or substituting for a fellow employee. Prohibition on city officers contracting with the city. The following city officers are prohibited from contracting with the city for the duration of the officer's term of office, excluding compensation or employment stemming from the officer's city position: mayor, city council members, city administrator, city attorney, city auditor, city controller, head of any city department, any person appointed as the chief executive officer under a board or commission, such as the executive director. Prohibition on city board and commission members contracting with the city. If you are a board or commission member, you are prohibited from contracting with the city for more than $10,000 in aggregate during your term in office, including the following boards and commissions: Children's Fund, Planning and Oversight Commission, Housing, Residential Rent and Relocation Board, Planning Commission, Port Commission, Public Ethics Commission, Police and Fire Retirement Board, any other city board or commission with decision-making authority beyond merely the making of recommendations. There are some exceptions. Please contact the PEC for more. Non-interference in administrative affairs. The city charter divides the duties and responsibilities of government among the city's elected and appointed officials. The mayor appoints and provides direction to the city administrator, who is authorized to administer the affairs of the city and to appoint, discipline, assign, or remove department heads and employees under his or her jurisdiction. City council members may not direct, coerce, or influence any city administrative staff under the jurisdiction of the mayor, city administrator, city auditor, city attorney, or city clerk. Council members may, however, make an inquiry to request data or information from department directors or authorized staff. Administrative Instruction, AI 597, provides more detail to employees under the city administrator's jurisdiction about Charter Section 218 and the procedure to respond to calls, inquiries, and/or other oral or written communications from individual council members and/or members of their staff. AI 597 defines inquiry as any non-directive request for information that does not require any of the following. 1. That the employee take an action that is contrary to existing departmental directions or deadlines. 2. Reordering of priorities established by the budget. 3. Preparation of new documents or reports. And 4. Expenditure of unbudgeted funds. Direction is defined as any order or directive to provide information, respond to a request, take or refrain from taking an action on a request, attempt to change or influence a recommendation, or ask a question that requires any of the 4 factors mentioned above. Examples of violations of the non-interference provision. A city council member calls an employee in the Public Works Department and tells the employee to go fix specific potholes in the council member's district. A city council member suggests a department director select a particular vendor for a contract. A city council member asks a city employee to draft amendments to a city ordinance. The purpose of the non-interference rule is to ensure that city staff serve the whole community in its administration of city services through the legislative directives of city council as a whole. A council member or their aides may ask questions and provide input, information, or feedback to city employees and department directors, but may not pressure, direct, or influence city employee activities. Why comply with ethics laws? There are several reasons why public servants should comply with ethics laws. To avoid potential criminal, civil, or administrative penalties, fines, and jail time. For personal reasons, reputation, professional development. Impact on city, community, citizens, and overall public trust in government. Compliance with ethics laws will help build and preserve public trust while upholding the integrity of city government. Let's review. As a public servant, you cannot participate in a decision that affects your own financial interests, including property, private business, and/or investments. Hold a position that has conflicting interests with your duties as a city employee. Go work for a company that you just hired as a contractor for the city. Use city letterhead, personnel, equipment, resources, or supplies for any personal use. Use city email to solicit support for a candidate running for office. Accept anything of value in exchange for the performance of any official act. Disclose confidential information. Supervise an employee who is also a relative. As a public servant, you can have friends who do business with or who are seeking to do business with the city. Pay your own way for meals and events. Use city phone for acceptable minimal personal use, such as emergencies. Receive payment for travel and related per diem from the city for education, training, or other interagency programs or purposes. Support a candidate and volunteer for their campaign on your own personal time. Remember, public office is a public trust. As a public servant, you are entrusted with making decisions about city resources. Your job is to make decisions and use your position for the good of the community, not for personal or political gain. The laws we just reviewed are considered the minimum or floor. We urge public servants to strive beyond mere compliance with the legal minimum and to always consider public perception and public interest as you make decisions in the course of your work for the city. Remember, you can always contact the Public Ethics Commission, the City Attorney's Office, or the FPPC with any question that you might have about state and local ethics laws.